Legal and Privacy Brief for May 6, 2026. The FTC, the Federal Trade Commission, settled with data broker Kachava, banning the sale of sensitive location data without consent. Germany advanced legislation permitting law enforcement to use automated facial recognition against public internet data. The Supreme Court rushed Louisiana redistricting while simultaneously blocking Texas map changes in December, raising consistency concerns. Here's the full breakdown of today's top legal and privacy stories. Legal and Privacy Brief May 6, 2026. Next section, Enforcement Actions. FTC, the Federal Trade Commission, bans data broker Kachava from selling sensitive location info. The Federal Trade Commission reached a settlement with data broker Kachava and its subsidiary Collective Data Solutions, blocking them from selling, sharing, or disclosing sensitive location data without consumers' explicit consent. The FTC's 2023 complaint alleged Kachava illegally obtained and sold consumers' yearly incomes, mobile device ID, app usage, and nearly real-time geolocation data within 10 meters. The company sold precise geolocation data, showing consumers visiting houses of worship and health care clinics without their consent. The proposed order does not impose a fine on Kachava, but requires the company to create a sensitive location data program cataloging sensitive locations, establish a supplier assessment program to confirm consumer consent, alert the FTC if third parties violate the settlement terms, and create a data retention schedule mandating predetermined deletion timeframes. Compliance action, review location data collection practices. Ensure explicit consent mechanisms are in place before collecting or sharing geolocation data, particularly for sensitive locations. Implement supplier assessment programs to verify consent chains. Establish data retention schedules with mandatory deletion timeframes. Sources: The Record. Conti, Akira ransomware affiliate, sentenced to 8 years. Latvian ransomware affiliate Denis Zolotarjovs was sentenced to more than 8 years in prison for conducting attacks on behalf of Conti, Akira, and other ransomware operations. Zolotarjovs pleaded guilty to money laundering and wire fraud charges after extradition from Georgia. He specialized in escalating pressure tactics during ransom negotiations, analyzing stolen data, and researching victims to force payment. In one incident, he became enraged when a pediatric healthcare company refused to pay and urged his group to leak or sell children's health information, escalating to sending samples of stolen pediatric data to hundreds of patients as a threat. Prosecutors said the organization he worked for operated from St. Petersburg, included multiple former Russian law enforcement officers, and caused $56 million in losses across 53 companies during Zolotarjovs' participation from June 2021 to March 2023. The organization remains active and was the second most observed malware family in 2025. Compliance action, review ransomware response plans. Ensure incident response procedures include communication protocols that avoid escalation tactics. Verify backup systems are offline and tested regularly. Consider tabletop exercises for pediatric healthcare and other organizations handling sensitive data about minors. Sources: The Record. Next section, Litigation Updates. Sony PlayStation Store settles antitrust class action for $7.85 million. Sony Interactive Entertainment agreed to a $7.85 million class action settlement, resolving claims it violated federal antitrust laws by monopolizing the PlayStation digital game market. The settlement addresses allegations that Sony's exclusive control over digital game distribution on PlayStation consoles constituted anti-competitive conduct. Sources: Top class actions. Eighth Circuit affirms dismissal of agricultural antitrust case for impermissible group pleading in INRI. Crop Inputs Antitrust Litigation, No. 243104. The Eighth Circuit affirmed dismissal with prejudice of an antitrust class action alleging suppliers of seeds, pesticides, and agricultural inputs conspired to refuse to sell to direct-to-consumer e-commerce platforms. The court determined the complaint failed for two reasons. Many factual allegations referred to manufacturer, wholesaler, or retailer defendants, collectively without identifying who did what, to whom, where, and when, constituting impermissible group pleading. Second, the remaining allegations failed to plead parallel conduct, as the complaint did not allege more than one defendant engaged in similar conduct around the same time. The decision establishes that plaintiffs alleging antitrust conspiracy must specify relevant acts by each defendant individually and connect each defendant's behavior to allegedly parallel actions of other defendants to plausibly plead an unlawful agreement under the Sherman Act. Compliance action. When drafting antitrust complaints or reviewing allegations, ensure specific factual allegations identify individual parties, actions, timing, and parallel conduct. Generic group allegations are insufficient, Sources: Inside Class Actions. DocketWise class action alleges data breach from inadequate security. A class action lawsuit alleges DocketWise, an immigration and case management solution company, failed to properly safeguard and secure the personally identifiable information of more than 116,000 consumers during a recent data breach. The complaint claims DocketWise's utter failure to protect information led to the breach. Compliance action: review security controls for case management systems handling sensitive personal information. Conduct vulnerability assessments on third-party immigration and legal software platforms. Verify encryption at rest and in transit for personally identifiable information. Sources: Top class actions. Next section: Regulatory guidance. Germany advances legislation expanding law enforcement surveillance technology. Germany's federal cabinet advanced a legislative package allowing law enforcement to use automated biometric image matching against publicly available internet data. The bills would legalize automated data analysis and artificial intelligence tools that let police upload a photo of a face and scour the internet for more images depicting the same person. Officers currently must perform manual searches of social networks and other internet sites. The German government defended the move, stating the bills would not create a state-controlled database of images stored indefinitely, and surveillance images collected in real time by public cameras will not be included. Coalition of more than a dozen civil society organizations opposed the package, stating it will fuel digital dragnets and create a mass surveillance state, violating fundamental constitutional and human rights grounds. On the same day, privacy advocacy group Neub filed a lawsuit against the Hamburg Data Protection Authority for allegedly not enforcing European laws making the facial recognition search engine PIM eyes illegal. Compliance action: monitor developments in EU biometric surveillance legislation. Organizations operating in Germany should assess how automated facial recognition laws may affect their data protection obligations. Review compliance with GDPR, the General Data Protection Regulation, requirements for biometric data processing. Sources: The Record. Trump administration plans AI model pre-vetting system. The Trump administration is discussing an executive order to create an AI working group, bringing together tech executives and government officials to examine potential oversight procedures. Among the potential plans is a formal government review process for new AI models. The administration previously revoked Biden's policy on AI safety reviews on day one. The planned approach would be more stringent than Biden's voluntary setup, which involved the U.S. Artificial Intelligence Safety Institute, USAC, within NIST, the National Institute of Standards and Technology, conducting basic standardized testing. The Trump version would require AI companies to provide the government with first access to models with significant cyber capabilities before deployment. Compliance action: AI developers should monitor executive order developments regarding pre-deployment vetting. Prepare for potential mandatory government review processes for frontier models. Assess whether current voluntary safety testing protocols will satisfy future compliance requirements. Sources: TechDirt. Australia establishes Cyber Incident Review Board. Australia announced the establishment of a Cyber Incident Review Board to conduct independent reviews following major cyber attacks. The board will carry out no-fault, post-incident reviews of significant cyber attacks on Australian government and industry, focusing on systemic lessons rather than individual or corporate culpability. It is modeled on the Cyber Safety Review Board established by the Biden administration in 2022, which produced 3 reports before being disbanded by the Trump administration. Unlike its U.S. counterpart, which relied entirely on voluntary cooperation, Australia's board can compel information from entities that decline to participate. Compliance action: organizations operating in Australia should prepare for potential cyber incident review board inquiries following significant cyber attacks. Establish procedures for responding to board requests. Review incident response documentation practices to ensure they support post-incident reviews. Sources: The Record. Next section: Privacy developments. EFF and 18 organizations urge UK to address root causes of online harm. EFF and 18 organizations wrote to UK policymakers urging them to address the root causes of online harm, rather than undermining the open web through blunt restrictions. The coalition warned that proposed measures, following passage of the Children's Wellbeing and Schools Bill, risk fundamentally reshaping the internet. Chief among these proposals are sweeping age-gating requirements and access restrictions that would apply not only to young people, but effectively to all users. The signatories argue these measures threaten the core architecture of the open internet. Age-gating at scale could fragment the web into a patchwork of restricted jurisdictions, limit access to information, and entrench the dominance of powerful gatekeepers. The coalition calls on UK policymakers to hold companies accountable for systemic practices and prioritize user rights by design rather than imposing access bans. Compliance action. Organizations offering services to UK users should monitor children's well-being and schools' bill implementation, assess potential age verification requirements and their impact on user privacy, review alternatives to age gating that address underlying design choices driving harm. Sources: EFF deep links. Next section, policy changes. Supreme Court rushes Louisiana redistricting certification while blocking Texas map. Changes. The Supreme Court agreed to rush making last week's Louisiana v. Calais ruling official, allowing Louisiana to speed up redistricting plans even though some voting has already started. Justice Alito agreed to compress the normal 32-day waiting period. In his response to Justice Jackson's dissent, Alito argued the 2026 congressional elections in Louisiana should not be held under a map held to be unconstitutional. However, in December, Alito blocked changes to Texas's unconstitutional gerrymander, stating Texas needed certainty on which map would govern the 2026 midterm elections, and that December was too late to interfere with the election map. The Louisiana ruling allows the state to potentially claim a state of emergency to halt in-progress voting and redraw districts. Sources: Scadu S. Blog Tech Dirt. Supreme Court declines to revisit Employment Division v. Smith. In religious exemption case, the Supreme Court agreed to hear argument next term in St. Mary Catholic Parish v. Rye, in which a Catholic preschool is challenging its exclusion from Colorado's universal preschool program by arguing Colorado must allow it to deny admission to LGBTQ children and children with LGBTQ parents. The justices declined to revisit or potentially overrule 1990's Employment Division v. Smith, which limits the reach of the First Amendment's free exercise clause. The court made the same move 4 years ago in 303 Creative LLC v. Lenny's, taking up the free speech claim but not the free exercise claim or the question of whether Smith should be overruled. 5 current justices indicated in 2021 they are considering overruling Smith, but the precedent continues to be acknowledged and applied. Sources: Scadu S. Blog. Next section, compliance takeaways. Location data collection. Implement explicit consent mechanisms before collecting geolocation data. Establish supplier assessment programs to verify consent throughout the data supply chain. Create data retention schedules with mandatory deletion timeframes for sensitive location information. Ransomware preparedness. Review incident response procedures to ensure they include communication protocols that avoid escalation tactics. Verify offline backup systems are tested regularly. Organizations handling sensitive data about minors should conduct tabletop exercises for ransomware scenarios. AI model development. Monitor executive order developments regarding AI pre-deployment vetting. Prepare for potential mandatory government review processes for frontier models with significant cyber capabilities. Biometric surveillance compliance. Organizations operating in Germany and the EU should assess how automated facial recognition legislation may affect data protection obligations. Review GDPR compliance for biometric data processing. UK age verification. Organizations offering services to UK users should monitor children's well-being and schools' bill implementation. Assess potential age verification requirements and their privacy impact. Consider alternatives to age gating that address design choices driving harm. That concludes today's legal and privacy brief from Carolina Clear Tech. For informational purposes only, not legal advice.